Well, good morning, everybody. Welcome to a City Law Breakfast. I'm Ross Sandler, Director of the Center for New York City Law, and I welcome you to these breakfasts. For those of you who have not been in this building before, I welcome you to the building as well. It's our new law school, been opened up for about 18 months, and we're very proud of it, and it is working beautifully for our students. These breakfasts, as you know, are co-sponsored with financial support from Con Edison, Verizon, the law firm of Greenberg Traurig, and the Murray Goodgold Foundation. I should say that Sally Goodgold had a serious operation over the holidays and has not recovered, and of course, we're not here today, but our thoughts are with her. The next breakfast will be on March 11th with E.J. McMahon. We'll be speaking about pensions. He's written about it, and of course, pensions are now much in the news every day, both the state and the city, and the issue will be pension reform. Today, we are really fortunate in having Michael Mukasey here to speak. His career is extremely distinguished as a lawyer, a judge, public official, and a person who has great personal interest and knowledge and experience on the issue of speaking about today, the terrorism issue. He's a graduate of Columbia University, Yale Law School. He was an assistant United States attorney in the Southern District, went on to private practice, became a federal judge in 1988, where he handled very important cases related to the topic. He, of course, was the judge in the Omar Abdul Rahman and El Sayed Nosair case related to the 1993 attempts in New York to bomb the World Trade Center and other sites. He also was involved with the Padilla case. He, and of course, was here in 2001 and experienced all of that in a personal way. He retired after being chief judge in the Southern District, where he was asked to take on, for lawyers and those of us who've actually had the privilege of being in the Department of Justice, really an important task, which was to restore the integrity to the department at a time when it could not be lower. And this he did with great skill, and we were very fortunate that he was the person selected in 1988 to go to the Department of Justice as Attorney General. He has agreed today to speak about this important topic of terrorism, and we are delighted and very pleased to bring to the podium Michael Mukasey.
Get this down here. I'd like to thank my good friend Ross Sandler for that wonderful introduction, and it's obvious from the introduction that he is my good friend. And also for the privilege of this podium, to thank you and New York Law School and the Center for the privilege of this podium. This is a school that contributes not only to educating lawyers for law practice in general, but also in particular with a focus on governance of this city. And as a citizen of this city, I have to tell you I'm very grateful for this institution and very honored to be here. In choosing this topic, it occurred to me that it would be an appropriate topic for me, that is where we are in the war on terror and how we got here, not only because it's a subject that's I've been involved with on and off for about 18 years, or since a prosecution that eventually came to be known as United States versus Omar Abdul Rahman et al. Landed on my desk, but also because we've just celebrated, if that's the word, quietly, and that definitely is the word, what was to have been the 1-year anniversary of the closing of the facility at Guantanamo Bay. Now, as you all know, Guantanamo Bay is still open, and so I thought I would deal with that topic and how it came to remain open, and also about where we are in the war on Islamist terror, which this entails a discussion of not only why that facility is still open, but also of how we got here and perhaps where we're likely to go. I'm going to do some historical review, both to help find answers to those questions and also so that you can understand why the answers are somewhat less than definite and a good deal less than satisfactory. Based on the evidence that I saw, the first encounter of this country with Islamist terrorism didn't start on September 11, 2001, or indeed on February 26, 1993, which was the date of what was then known as the World Trade Center bombing and later became known as the first World Trade Center bombing. It began in the late 1980s, and specifically at a shooting range out in Calverton, Long Island, when a group of FBI agents approached what they thought was a bunch of folks who were taking rather aggressive target practice, and thought that they would give them a toss, as they say in the business, and get their identification and so on. And these folks put them off and challenged them and said that they were engaged in what is now known as profiling. And the agents, being polite and politically correct, backed off. Forward to 1990. In October of 1990, a right-wing Israeli politician named Meir Kahane was assassinated at a ballroom here in Manhattan after giving a speech. The assailant was quickly caught, a man named El Said Nosser. It was immediately pronounced to be the lone act of a lone actor. The case wound up being so overtried that, notwithstanding that he had committed the crime in front of an audience that is about as large as this, he was actually acquitted of murder. But was convicted of using the gun with which he had committed the murder and was sentenced to 7 1/3 to 22 years in jail. What we now refer to as jihadi literature was seized from his apartment that discussed, among other things, toppling tall buildings in order to bring down Western civilization, but nobody paid any attention to that. It was put in a warehouse. It went largely unexamined. Well, it wasn't an isolated act by an isolated actor. In February 2003, what has become known since, as I said, as the first World Trade Center bombing occurred, killing 6 people, injuring hundreds others, causing millions of dollars in property damage. And among the demands of those who carried out that bombing was that Nosser be released from jail. When amateur video of Kahane's speech was reviewed, it was discovered that one of the people involved in the 1993 bombing was actually present in the ballroom that night. And in fact, Nosser was supposed to have made his escape by getting into a cab that was driven by another of the 1993 plotters, but he jumped into the wrong cab and therefore was captured. It turned out also that both of those people, and Nosser and others, had been present on that day at Calverton, Long Island, when the FBI agents challenged them for taking aggressive target practice. The response to the 1993 bombing was, of course, the conventional response: bring the perpetrators to justice. And they were. The 1993 bombers were convicted at a separate trial. Their spiritual leader, Sheikh Omar Abdul Rahman, known as the Blind Sheikh, and 9 or so others, including Nosser, were convicted of an overarching plot that included the Kahane murder, the 1993 Trade Center bombing, and a plot to blow up landmarks around New York. I should tell you that one of the other goals of that conspiracy was to assassinate Anwar Sadat when he visited. Was to assassinate Hosni Mubarak when he visited New York. Shades of today's headlines. Abdul Rahman, even at that time, had an impressive background. He was not only the spiritual advisor behind the 1993 bombing, he had been the spiritual advisor to the assassins of Anwar Sadat in 1981, and he was later from jail to issue the fatwa that provided Osama bin Laden with a theological justification for 9/11. Here I should add that given what is going on today in Egypt, the Western world is, I think, quite fortunate that Abdul Rahman is in jail, because he is the sort of charismatic figure who actually could have been, and in fact aspired to be, an Egyptian Khomeini, complete with recorded sermons being distributed to his followers. The possibility of a bad outcome today would be a lot more substantial if he were on the street. Although the 1993 bombing led to I think the debut of the phrase wake-up call, in fact, there was virtually no public focus at the time on what it is we were, in fact, dealing with and up against. I said a few moments ago that from what I had seen, this country's first encounter with Islamist or Islamism, occurred in the late 1980s out in Calverton, but that was not Islamism's first encounter with this country. That actually goes back to the late 1940s, when a man named Sayyid Qutb, who had been something of a hellraiser in Egypt, won a traveling fellowship, largely to get him out of the country. And he chose to travel to the United States. Specifically, he went to Greeley, Colorado. Now, it would be hard to think of a more placid place than Greeley, Colorado in the late 1940s. But Qutb was absolutely mortified by what he saw. The haircuts, the enthusiasm for sports, the political system, the mingling of the sexes in church outraged him. And he went back to Egypt, quit the civil service, and joined up with an organization that was already in existence, having been founded in the 1920s, called the Muslim Brotherhood. Been founded by a man named Hassan al-Banna, who was assassinated the year that Qutb left for the United States. Although the Muslim Brotherhood welcomed Nasser's coup in 1952 against the monarchy, believing that that would end corruption and bring about an Islamist state, they again were disappointed when Nasser didn't even ban the consumption of alcohol. Qutb continued his agitation, was in and out of jail, was eventually hanged in 1966, and became something of a contemporary saint. Many members of the Brotherhood fled to Saudi Arabia, where they found refuge and ideological sustenance. Qutb's brother was among those who fled and taught the doctrine in Saudi Arabia, and among his students was a man named Ayman al-Zawahiri, an Egyptian who is now number 2 in Al-Qaeda, and the pampered child of one of the richest construction families in Saudi Arabia, Osama bin Laden. Forward to 1996, reiterated in 1998, was bin Laden's declaration of war on the United States, which I think was treated here pretty much as quaint. Imagine some fellow in a cave in Afghanistan declaring war on the United States. And then came the bombing of the East Africa embassies in Kenya and Tanzania in 1998, and the response was another bring them to justice series of calls, and actually an indictment that named bin Laden as a co-defendant. Regrettably, bin Laden doesn't seem to have been impressed, or at least if he was impressed, he wasn't deterred, because in 2000, we had the bombing of the USS Cole that had actually been preceded by an attempt to bomb another U.S. destroyer called the Sullivans that failed only because the barge that they were carrying the explosives on sank. Throughout this period, we heard about terrorism, but not about what the people who were practicing the terrorism think, and unless you attended one or another of the trials involved, there was no suggestion that we should do anything other than round up the perpetrators after the fact and bring them to justice. And notwithstanding bin Laden's declarations, plural, of war, his detailed description of his grounds for the declaration, all of this came up upon us as something of a surprise on September 11, 2001, when we finally got specific about what we were supposed to be waking up to, or should have gotten specific. President Bush promised to put things on a different footing. Among other things, to the cry of bring them to justice was added the cry, bring justice to them. But regrettably, there was not, in fact, time to work out a long-term strategy and a clear-eyed focus on precisely what it was we were dealing with. It was announced that we were involved in a war on terror, not a war on Islamist terror, and certainly not a war on militant Islamism. And in a sense, it's hard for a number of reasons to blame anybody involved, including the president. This was something that had to be fit into the grid of American domestic life and political history, and we were very much on guard at the time and still are against the repetition of our treatment of the Japanese during World War II and of fomenting religious and ethnic tension in this country. We are also a society that is reluctant to examine other folks' religions, and for those two reasons we shun the notion of a war on any movement that is or claims to be inspired by a religion. Indeed, President Bush went out of his way to avoid inflaming passions, going so far as to tell us that, as he put it, Islam is a religion of peace. Second, there was a sense within the administration that this was not simply about an organization called Al-Qaeda, based in Afghanistan as it then was, but was about a more widespread tendency, although how widespread and precisely what remained unclear. There's been, of course, a great deal of discussion about whether the word war adequately describes the war on terror in either intellectual or practical terms, and I could probably spend all my time here discussing that issue alone. I think it's enough to suggest that it's the most serviceable term that we have, and it's certainly a lot better, in my view, than the term foreign contingency operation, which is the term that's favored by the current Secretary of Homeland Security. And even as I do acknowledge that there are not only intellectual but also practical difficulties with the term, and legal difficulties as well, if we're talking about building a legal architecture that gives the President the powers that he needs and at the same time allows for the kind of accountability for the use of those powers that can sustain them over a long period of time. To put it in very mundane terms, it's very hard to sustain a public awareness of a war when everybody can still make restaurant reservations and go to the movies. Despite a certain lack of strategic focus, there were in fact many successes during those first years, the most notable being that there were, for the next 7+ years, no successful attacks on this country. A great deal of this success, I believe, was due to the CIA interrogation program, which involved sifting through literally tens of thousands of detainees, focusing on those who seemed to have the most potential for providing us with intelligence and questioning them vigorously at times. CIA agents were knowledgeable, and people other than those who actually debriefed the detainees were schooled in what became known, and I think what is probably one of the worst PR campaigns since New Coke, as enhanced interrogation techniques. It sounds like a wash day product, doesn't it? Enhanced, get the whitest wash on the block. I think harsh techniques, coercive techniques, would have been a whole lot more accurate and in the end a whole lot less harmful, because when you use a euphemism like enhanced, it sounds as if you're trying to hide something that you believe to be horrible and that you're ashamed of. And that was, I think, a disastrous choice. But we actually learned a great deal through the CIA program. In fact, if you focus on only 3 of the detainees, Abu Zubaydah, Khalid Sheikh Mohammed, and Abdul Rahim al-Nashiri, you find that we got a huge trove of information. Zubaydah was a lieutenant high up and close to Khalid Sheikh Mohammed and close to Osama bin Laden. Khalid Sheikh Mohammed, I think, needs no introduction to this audience. He was the man who planned 9/11, and Nashiri was the man who was the architect of the Cole attacks. To elaborate on some of what we learned, one important thing we learned from Abu Zubaydah, according to George Tenet and General Hayden, both former heads of the CIA, was information that led to the arrest of Ramzi bin al-Shibh, who was the operational supervisor of 9/11. We frustrated an attack on Canary Wharf in England and Heathrow. We got Jose Padilla, known for plotting to plant a dirty bomb in this country, actually prosecuted for something a whole lot more doable and a whole lot more sinister, namely getting apartments in Florida, filling them with gas, and then detonating them using cell phones. We also learned from him that it was okay for members of al-Qaeda, so long as they resisted to the limit, when they reached the breaking point, to talk. And in fact, he said at one point, do this for all the brothers, that is, bring them to the breaking point. And that was something that proved enormously valuable with Khalid Sheikh Mohammed when we finally captured him, because when he finally got to the breaking point, he gave chalk talks. He became a lecturer on the subject of al-Qaeda, on how it was organized, on how it moved money, and on how it attracted adherents. We also learned specific information from him that resulted in the capture of people who were planning to develop a biological weapons capability in this country, and on and on. Nashiri was giving us stale information at the beginning, wound up giving us a whole lot fresher information after he was interrogated by the CIA. So far as devising a way of dealing with terrorists once they came within the jurisdiction of our legal system, that's a somewhat less successful story. President Bush signed an executive order that there would be military commissions right away, but there was a delay in implementing them, due in part to negotiations with our allies, including the British, who at first insisted that their nationals should be tried first, and then objected to many features of the military commissions, which of course would have had to apply to everyone. And in the end, several British nationals were released to that country rather than adjusting the procedures, including some who were plainly guilty of war crimes. When a mechanism was finally put in place, commission trials were ready to begin. The Supreme Court refused to permit the President on his own authority to establish a system of military commissions, and so the Congress obligingly passed the Military Commissions Act. But by the time the legal challenges to that had been exhausted, the principal architects of 9/11 were in custody, Khalid Sheikh Mohammed and the others, who would never have been captured but for the CIA program. We were at the point where Khalid Sheikh Mohammed's trial was ready to start. He had offered to plead guilty. By the time that happened, we had a new president. And President Obama disclosed that he would, number one, close Guantanamo within a year, number two, shut down immediately the CIA interrogation program, and limit interrogation techniques instead to the Army Field Manual, which is generally available on the internet and has been used for decades as a training manual for terrorists, and would shut down military commissions pending a study, which, as far as I know, has not been completed yet. The point of these orders, according to the administration, was to, quote, restore, unquote, standards of due process and the constitutional standards generally, and to retake the moral high ground. I don't know how many of you saw the videotape of the signing of these orders, but there was one moment that I found especially telling. After the President signed the order to close Guantanamo, he asked whether anybody had prepared or drafted an order or any procedures for how it was going to be done. And a voice off camera said that they were working on it. For me, I don't know about for you, a terrifying moment. As regards Guantanamo, it is a military, not a CIA facility. I visited Guantanamo in February of 2008. It is a state-of-the-art detention facility. It is a state-of-the-art trial facility. I have visited, forget maximum security, I have visited medium security facilities in this country, including principally federal facilities, and I will tell you that it compares favorably with them. I got to see the high-value detainees being monitored on closed-circuit television, other than Khalid Sheikh Mohammed, who was out of his cell visiting with a delegation from the International Committee of the Red Cross so that he could report to them on how terribly he was being treated. But I did get to visit his cell and found that it included in the adjoining room an exercise facility that, lo and behold, included an elliptical machine that was the same make and model as the one that I used to use at the Landsberg when I was Attorney General, except he didn't have to wait in line at the gym every morning. The courtroom that exists at Guantanamo is enormously expensive. It can handle high-security detainees. It has an advanced computer system that can handle classified information easily. The medical care at Guantanamo is better than the care that is for the prisoners, is better than the care that's given to their captors. The library includes many Islamic and other titles, as well as DVDs, but somehow the most popular title, at least when I was down there, was Walker, Texas Ranger. That's not to say that there isn't violence at Guantanamo. There's plenty of it, but it is directed by the prisoners at the guards, not the other way around. The guards have to wear plastic face shields when they go walking up and down the corridors, and of course when they go anywhere near the cells, to protect them against the cocktails of feces, urine, spittle, semen, and other liquids that are thrown at them on a regular basis. The Army Field Manual is now the limit of interrogation, meaning that it is, of course, available as a training method on the internet. The Army Field Manual is limited to techniques that can be used by the most raw recruit, so that if what is permissible is out here. The Army Field Manual is here. The current Attorney General said during the 2008 campaign that the prior administration had, in his words, authorized the use of torture, approved of secret electronic surveillance against American citizens, secretly detained U.S. citizens without due process of law, denied the writ of habeas corpus to hundreds of accused enemy combatants, and authorized the use of procedures that violate both international law and the United States Constitution, unquote. He said, in his words, "We owe the American people a reckoning." Well, the reckoning began in April of 2009 with the release of the CIA memos, of the OLC memos that had analyzed the CIA techniques and described why it was they were lawful. That was intended, I think, to create a furor. The furor didn't develop, but it did disclose, of course, to any terrorist who was reading them what the limits were of where the United States would go. There was no outrage, in fact, in response. It was obvious that the CIA and the Justice Department had gone to inordinate lengths to avoid violating the torture statute. He then announced that he was reopening the investigations of CIA agents who had conducted interrogations. These investigations had been closed years before with detailed prosecutive memos describing why it was they were closed. He announced that he was reopening them and conceded that he had made that announcement and made that decision without reading the prosecutive memos that explained why they had been closed. In June of 2009, Ahmed Gailani, who had been already indicted for the East Africa bombings but was being charged at Guantanamo with other crimes as well, was brought from Guantanamo to the United States to stand trial on an indictment that had already been filed. In rather a piece of bad timing, in November of 2009, Captain Nidal Malik Hassan, who had been in touch, I should say, with Anwar al-Awlaki, the spiritual advisor to a couple of the 9/11 plotters, shouted Allahu Akbar before he got up and shot 13 soldiers at Fort Hood, Texas, killed 13 soldiers and wounded about 30. And the president told us that it was something as to which we shouldn't jump to conclusions. 3 days later, also in November of 2009, the Attorney General directed an end to the military commission's proceedings against Khalid Sheikh Mohammed and announced that he was going to bring him to the United States, specifically to the Southern District of New York, to stand trial, and that would somehow uphold the rule of law. Which law, I have no idea. Certainly not the Military Commissions Act that directs that people charged with war crimes be tried before military commissions. Not only was it, in essence, a failure to uphold the Military Commissions Act, it was a frustration of something we've been trying to do for several hundreds of years, which is to civilize the laws of war. Essentially, what we tell people is if you wear uniforms, you follow a recognized chain of command, you carry your arms openly, and you don't target civilians, then you have certain rights. And one thing that happens to you is you get held until hostilities are over. This was the United States government saying that if you violate all of those rules, you get an even better deal. You get to come to a courtroom, you get a platform, you get a lawyer, and you get the possibility of an acquittal. In Christmas of 2009, Umar Farouk Abdul Muttalib was caught trying to set off a bomb in his underwear over Detroit. Instead of being treated as an intelligence asset, he was treated as a criminal defendant, was given Miranda warnings, notwithstanding that the only advantage of Miranda warnings is that they allow you to use a statement, and given the fact that he had committed his crime in front of a couple hundred witnesses, the need for his statement is, I think, open to question. It's too bad we didn't use him as an intelligence asset immediately, because the bomb that he tried to set off was of the same type that would later be used by bomb makers who were shipping packages into this country a couple of months ago. And had we been able to find out where he got his training and where that person was, that incident could conceivably have been prevented. After the fact, the Director of National Intelligence suggested that Abdul Muttalib should have been interrogated right away. under the program for interrogating high-value detainees that was supposed to replace the CIA program that had been abolished right after the inauguration. Trouble was that program wasn't up and running yet within a year at the time that Abdul Muttalib was captured. Although that program was not up and running, I should tell you that the reopened prosecution, the reopened investigation of the CIA agents who conducted the interrogations that had been closed years before, that reopened investigation was very much up and running, was calling witnesses before the grand jury at the time, which I think is very eloquent of the priorities that were in force. On May 1 of last year, the New York City Police discovered a primitive explosive device in an SUV parked near Times Square in New York. If it had gone off, it would have killed hundreds, but it didn't, of course, and the incident was treated dismissively at the beginning, including by the mayor, who said he thought ultimately it would be found that the device had been planted by somebody who was upset at the health care bill. It turned out that the person who planted the bomb, if he had any views about the health care bill, had not been motivated by them when he set the device. In fact, he had been trained by the Pakistan Taliban and had gotten his help from the Pakistani branch of the Taliban in order to do it. Even though the principal value of both of these people when they were captured was as intelligence assets, the main emphasis, of course, was on criminal prosecution and a rich trove of information. I would suggest he was forfeited. The Gailani trial appears to have been intended as a demonstration that we could try any Guantanamo detainee in a civilian court, and thus to serve as the basis for an argument that the expressed concerns over trying Khalid Sheikh Mohammed here in a civilian court were misplaced. As much as Gailani had been indicted years before, the case had been investigated years before as a case to be presented in a federal court rather than simply being based on evidence captured on the battlefield. Even if it had been a complete success, it would not have proved anything of the sort. But of course, as we all know, it fell out of bed in a number of respects, including suppression of the testimony of a witness, key witness, against Gailani, and his acquittal on a couple hundred murder counts, conviction on only one count, and that was conspiracy to destroy government property resulting in death. There have been more, since 9/11, there have been more than 24 Islamist plots aimed at this country, including not only those of Major Hassan, Abdul Muttalib, and Shahzad, but also those of Najibullah Azazi and his cohorts who were under prosecution in the Eastern District, Bryant Neal Venus and his against commuter railroads and subways in this city, plotters who attacked military personnel at Fort Dix, Quantico, Virginia, Goose Creek, South Carolina, those who murdered an Army recruiter in Little Rock, Arkansas, planned to blow up a synagogue in Riverdale, an office building in Dallas, a courthouse in Illinois, many, many others. And yet the criminal law paradigm is still setting the limit of the response. The Attorney General continues to press for a civilian trial for Khalid Sheikh Mohammed and others. He says that's not off the table, when they were scheduled long ago to have begun their military trials at Guantanamo. Nashiri, who was supposed to have been already tried in connection with the Cole bombing at Guantanamo, at first began his trial. It was stopped. We're now told that that trial has been put back on the rails. It is true that Guantanamo remains open, but it's also true that the president remains as committed as ever to closing it and to figuring out a way to release those who were there, despite a growing body of evidence that alumni of that institution have returned to the battlefield in startling numbers. A recent example is an interview with a man named Sheikh Abu Sufi al-Azdi, deputy commander of al-Qaeda in the Arabian Peninsula, which is a group based in Yemen, that was published in the October 2000 issue of that organization's English magazine called Inspired. For those of you who do not have a subscription to Inspire, I will tell you that you can get a copy of the article on the web at a website called Middle East Media Research Institute, MEMRI, which translates articles of that sort and others. It's a real eye-opener. This is a fellow who participated in who was released from Guantanamo, turned over to the Saudis for participation in their celebrated re-education program, but made his way back to Yemen to resume his jihadi activities. In this interview, he urges Muslims to emulate Nidal Hassan, the Fort Hood shooter, and Abdul Muttalib, the Detroit airplane bomber. He's by no means the first alumnus to return back to the battlefield. In March of 2010, the supreme leader of the Afghan Taliban announced that he was promoting an alumnus of Guantanamo to replace somebody who'd been killed by one of our drones. In fact, more than 20% of those released from Guantanamo have returned to the battlefield, and those are the ones we know about because they've been recaptured or killed in battle. How many others are still out there, we have no idea. With respect to Guantanamo, there is something of a constitutional standoff at the moment. The president wants to close it, wants to bring those who are still there here. Congress has said that he may not use funds appropriated by Congress for that purpose, and so we're at loggerheads. Another alternative that the administration, that some of the administration have urged and some outside it have urged, is indefinite detention at Guantanamo with no trial, at least until after the 2012 election. And that indefinite detention option has gotten backing even from some highly respected people on the outside, including a man named Jack Goldsmith, former Assistant Attorney General, and somebody with whom I ordinarily agree. Now, make no mistake, I'm not here as a proponent of military commissions as a policy matter, although I think that the fact that Congress has passed the Military Commissions Act and then repassed it at the behest of this current administration makes it barely short of lawless for the administration to refuse to use military commissions. But I certainly agree that the record of proceedings in that forum is not encouraging. Omar Khadr, who at the age of 15 and without disclosing his identity as a combatant, threw a hand grenade that killed one U.S. soldier and maimed another, was allowed to plead guilty and get a sentence that was capped at 8 years to serve the remainder of his sentence in his native Canada, where the laws are such that he's likely to be out in a year or two. And that sentence itself was harsh compared to the treatment that Osama bin Laden's bodyguard and confidant, a man named Salim Hamdan, who gave his name to a famous Supreme Court case, received. He was bin Laden's driver. He was captured in possession of 2 missiles that were intended for use on U.S. soldiers. Anybody here who has either handled or is familiar with organized crime cases knows that the driver is probably the most trusted member of the family. He's the one who's closest to the boss. He's the one who's responsible for the boss's safety, and he's the one who hears everything. Notwithstanding that, the military judge couldn't get his mind around the fact that Hamdan was anything but a driver. The prosecution asked for 30 years. Hamdan got something short of 8 and was released immediately because he'd already been in custody for longer than then. On the other hand, as I said earlier, trying unlawful combatants in civilian courts disregards the military commission statute and essentially provides them with better treatment than that's accorded to those who obey the laws of war. So what are we to do? One thing that perhaps ought to be done is to go back to first principles and ask why it is we want to have trials, if we do. And it's not just because we're lawyers. You wind us up and we try cases. After World War II, we held the Nuremberg trials essentially for 2 reasons. One was to create a record of what the people involved in the Nazi regime had done, and the second was punishment. Not everybody at the time favored the Nuremberg tribunals. Winston Churchill, in fact, favored summary execution for the senior leadership of the German government. He didn't see any need for trials. Well, we don't need the record-keeping feature of Nuremberg today. We have a record of precisely what it is these folks have done and why they've done it. I don't think that simply that indefinite detention or even summary execution is a reasonable choice, because it fails to provide for what I think the public has a legitimate and basic right to and a societal need for, and that is to affix moral blame and then to impose an appropriate punishment. That's why we have a justice system. Essentially, we have a social contract, as you know, in which people give up their right to use force in return for the assurance that their government will use force on their behalf when necessary. Telling the families of those who were killed on 9/11 not to worry because we're going to have these folks in custody indefinitely, I would suggest to you is a failure of the government's part of the social contract. One solution that is available to Congress is to exercise its constitutional power to create a court to try terrorism cases. Article 3 authorizes Congress to create, Article 3 provides only for the Supreme Court. It then says, such other courts as Congress may from time to time ordain and establish. Congress has the power to create courts. It can create a court that can consider any relevant evidence, isn't bound by the rules of evidence, and can be fashioned to try these cases. It could be presided over by an Article 3 judge, with the military providing juries and providing prosecutors. That's one alternative that's been proposed. There's been a lot written on this. This is not the time to get into a detailed description of how it would work, but that is certainly one alternative to what we have. In the executive, I think we need to focus on the nature of the adversary that we confront. Strategically, there's been not only a failure, but an outright active refusal to consider the nature of the adversary we confront, and that is an adversary that's motivated by a religiously derived ideology that essentially offers to infidels three choices: conversion, dimitude, or death. And we live in a culture, as I said before, in which we hesitate to ask questions about other people's religion. But when that religion is something they use as a justification for imposing a system on us, we are very well entitled to ask questions about it and to draw appropriate conclusions. Because we are facing a militant ideology that's not focused in any one particular place, the only way that we can prevail is to try to stay a jump ahead of those who are intent on translating that into concrete action. And the only way to do that is through intelligence gathering, both electronic intelligence and, when we can get it, human intelligence. And I would not downplay, as many people have, the value of human intelligence. General Hayden, former director of the CIA, said that trying to work based only on electronic intelligence is like trying to solve a jigsaw puzzle without looking at the picture on the box. Occasionally, we get hold of a person who can describe what the picture is on the box, and that is enormously invaluable. However, if we have a program for questioning potentially valuable detainees that's limited to the Army Field Manual, that's already, as I said, available on the web as a training manual, we're going to be getting virtually nothing. There are certainly those in the intelligence community who understand the nature of the threat and the importance of intelligence in dealing with it, but those in charge appear to be strategically myopic. The President's Special Assistant, Deputy National Security Advisor, made a speech last year at the Center for Strategic and International Studies. This is in 2010, and this is one of the White House's designated deep thinkers on the subject of terrorism, talking to other deep thinkers, in which he said that to speak of a war on terrorism or a war on terror is highly misleading because terrorism is simply a tactic and terror is a state of mind. When I heard that, I thought back to a great comedic routine that was part of a show that virtually everybody here is too young to remember, called Beyond the Fringe. It was a revue that ran on Broadway, and one of the wonderful bits in that revue involved a harassed Scotland Yard spokesman trying to explain why it was that Scotland Yard had failed to solve the great train robbery of 1963. And he said that Scotland Yard had been very confused by the name Great Train Robbery. He said, trains are very large, they're hard to conceal, they run on rails, very difficult to make off with them. We've investigated this and we found that there's no question at all of a missing train. We have the train, it's the contents of the train that are missing. That's a very funny bit because it's part of a British farce. The President's Deputy National Security Advisor did not, so far as I know, intend himself to be participating in a British farce when he spoke at the Center for Strategic and International Studies about the war on terror. When he got to the subject of jihad, he cautioned against describing our enemies as jihadists because, as he put it, jihad is, quote, a holy struggle, a legitimate tenet of Islam, And then just so that nobody missed the point, he said that jihad actually means, simply as he put it, to purify oneself or one's community. This person, by the way, says that he believes that a 20% recidivism rate from Guantanamo is actually not bad because it compares favorably with the recidivism rate in federal institutions, notwithstanding, of course, that we have a whole lot more accurate way of keeping track of the alumni of federal institutions than we do of the alumni of Guantanamo. Now, we can wish Muslims of a reformist bent all the luck in the world without forgetting that it's going to take a struggle within Islam and not wishful thinking to change the meaning of jihad, or at least the lengths to which some Muslims are willing to go in following it. Jihad may indeed involve purification, but only in the sense of intensifying one's own commitment to calling others to the faith and spreading Sharia law and purifying one's community of all non-Islamic influences. We can wish reform-minded Muslims and moderate Muslims all the luck in the world without forgetting that the struggle to spread Sharia by peaceful means if possible, but by violent means if necessary, is in fact the meaning of jihad within the religion. Now, I recognize that all religions, my own included, have universalist visions and look forward to the day when all people will worship in accordance with them. But where they differ sharply is on how far they command people to go in bringing that day about. For the people in charge to overlook that, or if they haven't overlooked it, to try to get other people to overlook it, I suggest to you is a bad way to lead us. And that, regrettably, is where we are. I'll now be happy to take your questions.
Let me just take a moment. Commissioner Ray Kelly was here for your talk. I did want to acknowledge him, but he just ducked out. But I think it's a tribute to you and to the topic that he came this morning. I also would like to acknowledge Judge Loretta Preska, who is the Chief Judge of the Southern District and who sits in, I guess, the chair that you once sat in and does that very well. Open up to questions. Microphones here. This is a very, I would say one thing about this talk. I was very interested in having Mike Mukasey come because in law schools, notoriously quite liberal in their points of view, bringing somebody who would speak on this topic from not quite that point of view, I thought was exceedingly important, and I am really grateful to you for coming and delivering what I think has been a really important and thorough review of this whole issue. So questions, comments, just go to the microphone. Peter, right over there so people can hear you and we get it on tape.
I'm wondering whether you could elaborate on your opposition to military commissions, or at least you said as a public policy matter you were not a fan of those. And if we don't have civilian trials in the U.S. and we don't have military commissions, what alternative do you propose?
We've had military commissions since the Revolution. There was a military commission convened as late as World War II when German saboteurs landed off Long Island in Florida in 1943 and were captured, and on direct orders of the president, they were not taken to a civilian court. They were put before a military commission, tried, and executed within 3 months. In fact, the Supreme Court opinion upholding that entire procedure was issued after they were dead. However, we don't have any experience with military commissions on a long-term basis, and military commissions are something apart from the normal mandate of the military. Military services are there to fight and win wars, and military commissions are, from their standpoint, and justifiably, and I don't mean this as a criticism of them, military commissions are a sideshow. They are not within the mainstream of the mandate of the military. There's no promotion track for being successful long-term prosecuting military commission cases. People do a limited term there and then they move on to something else. There's no long-term mechanism in place. And I think there has to be a long-term mechanism in place, which is why I suggested creating a terrorism court. I think civilian courts create enormous security concerns, not to mention the fact that when we bring people within the reach of federal courts, what we invite And whether we invite it or not, what we're going to get, because the lawyers involved have announced that it is what we're going to get, is a wave of litigation addressed to the fact and the conditions of confinement of people who are brought here. And federal courts are going to be basically put upon with an enormous wave of litigation over each of these people. There are several hundred federal judges across the country. And I have to tell you, I yield to no one, or at least to no one except several federal judges, in my admiration for the federal judiciary. However, there is always one federal judge who will release somebody on a habeas corpus writ on a claim that that person's confinement is no longer warranted. That's not possible at Guantanamo. It is possible once people get here. And it will be particularly possible when and if we start withdrawing troops from Iraq and Afghanistan, which will then give rise to the claim that, hey, the war is over, and therefore we can't continue to hold people. So I find that part of it enormously dangerous, which is why I believe in creation of a separate court. Yes?
Just one quick follow-up. There's already on the books a terrorism court authority. It's not been used.
There's a
Patriot Act.
there's a FISA court. If there's a terrorism court, then it ought to be used.
Okay, Bruce Logan here, thank you. I love your analogy of the Great Train Robbery. The train hasn't been stolen, but the contents were stolen. The contents of our freedom and liberty have been stolen, not the Constitution, so to speak. So what is your remedy for getting back the contents?
I'm at a loss to know which of our liberties have been stolen. As far as I know, everybody remains free, and if you consult the blogs, quite free, to launch whatever criticism they want, fact-based and otherwise, to conduct whatever protests they want, fact-based and otherwise. I've never seen such a procession of people line up at microphones like this to complain that their free speech rights are being suppressed.
Oh, I'm not complaining about it. I'm very much appreciative of your wonderful analogy. I'm not precisely because we can line up, we have the freedom to do that. I'm just concerned about how do we get back the sense of freedom that we have. I think that's a better question.
We get back the sense of freedom that we had when we stop having to wake up every morning wondering whether a bomb is going to go off in the subways.
Okay, thank you.
James Perricone, good morning,
Morning.
Judge. Judge, I was puzzled by one thing in particular in your talk. You mentioned that there was little furor or notice taken of this is on the question of CIA aggressive interrogation techniques. You said there was little furor over the release of the memos that justified some of those techniques, especially, of course, waterboarding. And I don't know what media you were or weren't reading, but I remember a very significant furor, and I believe that some of the memos were released in bits and pieces, so it didn't sort of happen, all at once. But all of that aside, whether the media made a big deal or whether there was a furor, do you still feel that those enhanced techniques had sufficient legal support in the memos that John Yoo and Bob Delahuntty and others were involved in producing?
The short answer to your question, until you got to the last part of it, was yes. So far as John Yoo's memos, those were withdrawn. I think that they were not well done. They were redone. What's interesting about the fact that they were redone is the fact that the same conclusions were reached, namely that the techniques were lawful. Torture has a meaning. It's not just an expression. There's a statute that bars the use of torture, which defines torture as acting under color of law for the purpose of causing severe physical or mental pain or suffering. And mental pain or suffering is defined as having long-term consequences. Waterboarding, I will tell you, creates virtually no physical pain and has no long-term consequences. It is used in SEER training for special forces and for Navy SEALs. And it has to be used with great discretion in SEER training because it can be very demoralizing because they always give up whatever it is they're trying to hold back. And I'll be happy to talk to folks about what it involves if you want to hear it.
Well, I think you'll recognize that there was an extreme revulsion among the American people generally when it was learned what waterboarding techniques were like. Is that of no moment in evaluating?
I will recognize that there was extreme revulsion against a general concept of waterboarding that included what the Japanese did during World War II and what the Khmer Rouge did later on. This bears no relation to that. What the Japanese did during World War II was to lie people down, pump water down their stomachs, and then stand on their abdomens and push it back up. They also forced them to eat raw rice and pump water down their stomachs and waited until it distended and caused enormous pain. That's not what the CIA did. The Khmer Rouge handcuffed people to the bottom of barrels and poured water in until it reached over their heads. That was their idea of waterboarding. Now that I've described that, I best, it seems to me, describe what's involved in CIA waterboarding, which is strapping some, and I should tell you, by the way, that 3 people, count them, folks, 3 people, the 3 people I discussed, Abu Zubaydah, KSM, and Nashiri were waterboarded. That's it. It involves tying somebody down to a board, putting a cloth over his face, pouring water over his nose and mouth, and holding your hand so that he doesn't move his head to get the water away for periods of between 20 and 40 seconds. That's it. What it creates is panic. It creates the panic of drowning, even if you know you're not drowning. And of course, by the 2nd or 3rd time they do it, you know they're not going to drown you. And of course, the trainees who undergo SEER training know they're not going to be drowned. And it works every single time.
Works to do what? I'm sorry.
It works to force people to be cooperative. And it is not, by the way, a question of trying to get confessions out of people. I will concede that if you had waterboarded KSM enough, he would have confessed to having shot Abraham Lincoln. Confessions aren't the point. Intelligence is. And what you do is, when somebody lies to you in the course of questioning, you take them out and you engage in coercive techniques with the authorization of somebody at the deputy level or higher within the CIA, and wait until he becomes more cooperative, and then somebody who does the questioning comes in. It's not the same person, and it certainly isn't engaging in that technique until somebody discloses a particular piece of information and then running out and using it. You take the information that you get, fit it into the grid of information that you've already got to determine what it is that you're getting. And what we got was enormously valuable. And that was not the only technique used. There were a whole lot of other unattractive techniques. Sleep deprivation, walling, which involves banging somebody into a hollowed-out wall that makes a sound, that makes it sound as if he's being pushed with a whole lot more force than he is, and open-handed slaps to the side of the head and the abdomen.
Thank you.
Yes.
Just a preliminary question.
How are you?
Your Honor. Fine, Your Honor. Fine. What is SEER training?
It stands for Survival, Evasion, Resistance, and Escape.
Survival.
Evasion, Resistance, and Escape.
Resistance,
And it is something that Special Forces and SEALs undergo.
Good acronym. This is my, first, I want to say that I'm one person in this audience who generally approves of what you've been doing, and thank you for your public service. And you should not assume that everyone is revulsed by what you said. What is the, obviously you're in sharp disagreement with the current Attorney General.
I'm sorry?
You're in disagreement on a lot of issues.
I have some policy disagreements with
With
him.
the current, and I assume you have some disagreements with the Attorney.
I have some agreements with him, too. I think that the current department has been, in a quiet sort of way, enormously aggressive about pursuing leak cases, and I applaud them for that.
And
I'm deadly serious. I think that that's an enormous problem, and they're serious about cracking down on it.
And I assume you had some disagreements with your predecessor, the Attorney General you replaced, Alberto Gonzales, without asking you to go into them.
Okay?
But you're different. Now, this is my question. How is it made more difficult, much more difficult, to conduct our anti-terrorist and anti-jihad operations or relations with other countries when the administration is not in sympathy with the techniques you describe, what you're doing, the sanctions, the attitude that you show. I mean, when there's such a sharp difference between what you say and think and the way this anti-terror activities are now being conducted, is that impeding our ability to fight and prevent further incidents?
It's not something I can prove. I cited the Abdul Muttalib incident and the incident in Times Square as examples of situations in which we could have gotten intelligence that we didn't get. I don't know what other incidents there were, how many other incidents there were. But what I'm saying is that going back to a criminal law paradigm is no way to do it. That said, they have left in place and are pursuing the techniques that were approved for electronic surveillance. Those are very much in place. And those obviously come a great deal in handy, but that's only part of the equation.
It's a mix.
It's a mix.
Thank you.
Let me just say to Roger, last question, so you're not going to get to ask your question. We're over time. Last question. Yes, you may go.
Yes, I'd like to go back to your question, or your statement with regard to the difference between the military commissions and the civilian courts, the possible right of acquittal. You found reprehensible in the civilian courts, if I heard you correctly. I'd like to
No, I
know if
didn't
your
say
new
that.
courts
I didn't say the possible.
would obviate that.
Not at all. What I said was that the fact of the acquittal, due to the suppression of evidence, was a regrettable result. But you cannot have a trial unless you have the possibility of an acquittal. Otherwise, it's not a trial. Otherwise, it's a show trial.
Thank you.
You have the possibility of an acquittal in military courts. In fact, military courts generally, including courts martial, have a higher record of acquittal than civilian courts. It was the fact and the manner of the acquittal in the Gailani case that I objected to, not that acquittal is a reprehensible result.
Good. Well, this brings this breakfast to a close. I want to thank Michael Mukasey again for really what we hope to achieve in these breakfasts is bringing important views to the law school, to the community, and no one has ever done it better than you did today, and we really are appreciative. As we always do, we'd like to give a product of the scholarship of the law school to the speaker, and this is the book, Breaking the Logjam, Environmental Protection That Will Work. It's a proposal and series of analysis of the environmental laws of the United States by David Schoenbrod, who's here, and other professors, and we give it to you with great gratitude for your visit to New York Law School. Thank you so much.